Good morning, everybody. I'm sorry for the technical delays this morning. Daniela, our superstar, is not with us, and I'm going to be taking it over today. Our topic that we are doing today is the unpacking of the relationships between service providers. Just hold on. There you go. Unpacking the relationships between property practitioners and service providers. This is a topic that we're seeing quite a lot of being asked in the industry, and with a lot of uncertainty, as there's not a whole lot of people explaining what exactly is going on there. So we've got with us today, we've got Willie Roos, Stratafin CEO. Willie is practiced as a property practitioner for over 20 years and was a managing agent in the sectional title industry for 8 years, where he dealt with the various issues that come up in the sectional title industry on a day-to-day basis. In 2014, Willie was one of the founding members of Stratafin, who built the company with the aim to assist body corporates with funding in a fair and ethical manner. Also with us today, we've got Dilen Heerschop that's joining us as part of the Twernberger attorneys. He is a legal practitioner with the High Court and is specialized in community schemes and has conducted various seminars and done various training seminars with NAMA, as well as with other podcasts such as Fazan Attorneys. He has obtained his LLB and has also completed his master's in specializing with the community scheme specialists. Willie?
Thank you, guys. Happy that we can eventually be with you. We had some technical difficulties here on our side, and I just want to say welcome to Dilen. Dilen has joined DTB Attorneys as a community scheme specialist. We don't normally tell you guys who the attorneys are that we deal with, because that's part of what we do, is that we deal with specific attorneys that can comply with the requirements that we want them to comply with. And we're giving a bit of our secret away today. So Dilen has joined DTB, and he's going to take us through the whole webinar today. I'll jump in wherever, and we will also ask you to put your questions in the questions and answers. And then we will try and answer as many as possible. Where we don't answer them during the webinar, we will definitely do so in writing after the webinar and send that out to all of you. So from here, over to Dilen.
Just from our side, this webinar is being recorded. We will email it out to all the participants. We will also make it available on our YouTube link for anybody that has missed it. And then we will also send out emails with the questions that we did not answer. There is also a free resource that will be shared alongside with this webinar recording. Okay, Dilen, on to you.
Thank you very much, guys. And thank you, Willie, for the opportunity. It's always wonderful to express ideas and have these types of debates and discussions on particular aspects, especially relating to new aspects. And I think the Property Practitioners Act is one of the aspects that's on everyone's list or on everyone's lips this year as well. So just by way of introduction, on the 14th of January this year, the proclamation was published. It's the regulations to the Property Practitioners Act, announcing the commencement date of the Property Practitioners Act. So as from the 1st of February 2022, property practitioners must comply with the Property Practitioners Act and its regulations. So just for interest's sake and for understanding's sake, the Property Practitioners Act has now repealed and replaced the Estate Agency Affairs Act, or the EAAA. And today we'll have a chat about the significant changes to practice as a managing agent, and then also we'll touch on estate agents and rental agents. So just by way of introduction and a very high level overview, because this is not why we're here today, but I think it's important for us to consider some of the notable changes from the EAAA, or the Estate Agency Affairs Act, and now to the Property Practitioners Act. So as I've mentioned, we have now replaced the governing body or the watchdog, so that we no longer have the Estate Agency Affairs Board, as this has been replaced with the Property Practitioners Regulatory Authority. Secondly, it's more widely applicable to major role players in the industry. So for example, this act seeks to regulate administrators, executive managing agents, and it goes so far as to apply to bond originators as well. Another important change is the aspect of candidate property practitioners. So we now have these candidate property practitioners, and before you can get your full status property practitioner, you would have to be suitably qualified and suitably experienced. Just as an interesting remark here, what we need to understand, there is a transitional provision in the Property Practitioners Act which states that any code of conduct or regulation or even a practice from the EAAA or something that was prescribed by the EAAB will still be in force and effect until the PPRA replaces that with a new code of conduct. So we've had a lot of questions on the aspect of NQF level 4, NQF level 5. Does this still apply? We need to understand the fact that as there's this transitional provision and there's not yet any codes of conduct that was issued from the PPRA's end, we still apply the previous requirements for us to become these property practitioners. Another interesting aspect is the fidelity fund and indemnity insurance requirements. All of us may know that we are required to have a fidelity fund certificate. Most of us probably has a fidelity fund certificate, but the new interesting one is the indemnity insurance. And just for a little understanding, we need to know the difference between fidelity fund and indemnity insurance. So fidelity fund relates to the misappropriation of trust funds that was held on behalf of a community scheme. So the moment we dip our hands in the proverbial cookie jar, that is when the fidelity fund coverage will kick in. But we need to understand that indemnity insurance is a bit different, and this relates to acts of professional negligence, and as a result of that, we have now incurred certain damages, and the indemnity insurance will then in turn cover for such losses. Just for you guys also to note that there is not a lot of indemnity insurance currently underwriting the property practitioners, so we'll have to wait and see. But the Property Practitioners Regulatory Authority and members of the cabinet are currently consulting with respective role players in order for us to get this indemnity insurance. Another thing, and I think it's nothing new to us, but they have now again re-encapsulated the requirement of having a trust account, and also they do have bookkeeping standards as property practitioners. And I think aspect number 6, and this is the one why all of us are here, we'll deal with it extensively, is the prohibition on the relationships with service providers. And then lastly, it also relates to document retention. So as we all know, we have to retain all documents of administration for a period of 6 years. It's still that way. And then secondly, there's also changes to letterheads. So for any letter that we do send, we need to indicate whether we are property practitioners, whether we are candidate property practitioners, or the like. So something that I think Willie and I discussed earlier, and it's something that's worth having a bit of a discussion, is the standard of training in respect of managing agents versus estate agents. Willie, do you have anything to add there?
Yeah, the discussion that you and I had was specifically that the training that is currently out there is focused on estate agents, and managing agents is a completely different creature, and it is actually so sad that we don't have specific training requirements in respect of managing agents, so that they form a subclass basically, and that they have different training. So that is something I think that the industry should work on. I know that the University of Pretoria is looking currently at that, and I also know that NAMA is also looking at that. So there are people that are looking at that, but at the moment, it is actually strange that you need to be qualified as an estate agent, or you need to know how to sell a house or rent a property, but in actual fact have very little knowledge in respect of management of schemes and the rules and so forth surrounding that. And that is definitely something that needs to change. I mean, the other thing that we also touched on is the indemnity. So the indemnity insurance indicates that there should be a standard of professionalism on the side of the managing agent. And where that is breached, then obviously you will have a claim against them. The current situation in terms of the Sectional Title Schemes Management Act and the old Sectional Titles Act and the rules as they were under that act specifically refers to the relationship between a managing agent and the scheme as that of master and servant. So in actual fact, you are just doing what you are told to be doing. So as a managing agent has no authority out of his own to perform certain functions and duties. It can only do things that they are required to do by the trustees. And one wonders how, under those circumstances, indemnity insurance can be applicable, because, I mean, if you're doing what you are being told to do, then why do you require insurance? But I think we are moving towards a new dispensation. And I think we've had a webinar, the last time that we had a webinar, or two or three webinars back, where we were discussing this relationship, and where we're saying that that relationship should become a professional relationship. So a managing agent should be a professional, and it should be similar to that of an attorney or a CA, an accountant, and have a fiduciary duty towards the scheme. And then one can understand why indemnity insurance would be required. What do you think about?
Yeah, I completely agree with you, Willie. I mean, if you have to conduct all of these onerous requirements to become a property practitioner, we might as well move away from this agency relationship and professionalize the industry a bit more. And I completely agree with the standard of training, and that we need to focus it a bit more on the respective sub-industries in the game. I mean, for example, from a managing agent's perspective, I think it's much more constructive for us to ensure that we know how to compile a budget, or how to conduct a members meeting. I think that's far more important than having to learn all of the things that an estate agent has to do.
Yeah, so it would be much better for you to know how to do a budget than to do a comparative market analysis.
Exactly that.
So,
exactly that.
Yeah.
Yeah, I think, okay, so the next thing that we just want to touch on a bit before we get into the nitty-gritties of how to appoint a service provider is we need to understand who appoints a service provider. So in terms of the prescribed management rules, and I mean, normally the law pertaining to community schemes, whether that's an HOA or a body corporate, they seem to follow one another, but the gist remains the same, that the trustees must appoint any agent or employee in terms of Section 4A of the Act, in terms of a duly signed written contract. So I think without any doubt, we need to understand that at any point when we do appoint a service provider, appoint a managing agent, we need to understand that this is a competence or a responsibility of the scheme executives. And then just
also needs to be done in writing.
Yes, it needs to, yeah, it needs to be a written contract. And then also we need to take caution when we make these types of appointments, because we need to remember, as scheme executives, we do have this fiduciary position and this fiduciary responsibility towards our community scheme. So each trustee of a body corporate must and does stand in a fiduciary relationship to the body corporate. And without derogating from the generality of the expression fiduciary relationship, the provisions of subsection 1 implies that a trustee must firstly, in relation to a body corporate, act honestly and in good faith, and in particular, exercise his or her powers in terms of this act in the interest and for the benefit of the body corporate, And this means not necessarily for your own personal interest, but for the interest from a scheme as a whole. And secondly, you must also act within your scope of powers. So you cannot simply do whatever you want. This is not a aristocracy or whatever. It is a democracy, majority rules and all of this. So we need to ensure that we don't exceed our powers when exercising our responsibilities. Secondly, as a trustee and as we have this fiduciary relationship, we need to avoid any material conflict of interest between his or her own interest and those of the body corporate, and in particular, not receive any personal economic benefit, whether that's directly or indirectly from the body corporate or from any other person. And then secondly, we need to notify each and every trustee of the nature and extent of any direct or indirect material interest which they may have when a decision is made. So we cannot simply stand by or even vote or participate in a decision where we have an interest, and we need to disclose this interest to our other scheme executives when there is this conflict, let's call it that.
Yeah, in practice, that what it means is that you have to disclose that you have an interest. So if it is your company that is going to paint the scheme, you have to disclose that. And then you have to excuse yourself from the decision-making process in respect of that decision that needs to be made. And if the decision is then made that your business can do the painting, then so be it. Then it's no longer a conflict of interest because it was disclosed and you did not form part of that decision. So from that point of view, you have not acted outside of your fiduciary duty. But we see in practice that this does not happen. We see that trustees get involved in the decision-making process whilst they have personal interest. And I think that's something that needs to stop and come to an end. But I think also, whilst dealing with the Act further, I mean, you will deal with that a bit later on again.
Yeah. So just to jump in here as well, I've seen a question: does this relate to an HOA? So the guidelines that we give in and this fiduciary relationship that you do have most definitely applies in the case of an HOA. We've just seen that it's codified so nicely in the Sectional Title Schemes Management Act. That's why we're making this the center of the discussion.
Yeah, in a company, that Company Act applies in general, and under those circumstances, then the fiduciary duties that is placed on directors, and I think there are far more requirements in respect of company directors than trustees. So I think it is a far more onerous position even under HOA.
Yeah, and I mean, this is what I'm going to say now is probably not going to happen to the people in this chat, but let's say in the unlikely event of you having a conflict of interest and you're not disclosing this as a scheme executive, what recourse does the body corporate have against you? And you can find that in subsection 3 that says a trustee of a body corporate who acts in breach of his or her fiduciary relationship is liable to the body corporate for any loss suffered as a result thereof by the body corporate, and secondly, any economic benefit received by the trustee by reason thereof. So you may have thought that it's a good idea not to disclose this interest, but the moment that they do realize it, all of those economic benefits that you may have received is reclaimable and it's going to be payable back to the community scheme. And then just an exception, except as regards the duty referred to in section 2A1, any particular conduct of a trustee does not constitute a breach of a duty arising from his or her fiduciary relationship to the body corporate if such conduct was preceded or followed by the written approval of all members of the body corporate, where such members were or are cognizant of all material facts. Okay, so now we're bringing all of these philosophical terms back to the Property Practitioners Act. So now we need to understand who is this property practitioner, and take note, should we have read the whole definition, you can go and have a look in the Property Practitioners Act. This webinar would probably continue until 5. So we've just now aligned it to the particular aspect and to the particular managing agent aspect of the definition. So the definition of a property practitioner in subsection 1C of the Property Practitioners Act states that a property practitioner includes any person who for remuneration manages a property on behalf of another. And then just to further encapsulate the fact that a managing agent does manage on behalf of another and receives remuneration, the regulations to the Property Practitioners Act make specific reference to a managing agent and their inclusion as property practitioners. So there is no doubt as to whether or not a managing agent who conducts a general managing agent role is a property practitioner.
So Dilen, so Dilen, what I wanted to ask, under this definition, would one consider a executive managing agent, a professional trustee, for example, would that be a property practitioner? And also then trustees that where the body corporate has voted to remunerate them for their services. What would be the situation with these three categories of people under the Act?
So what I can tell you, and I'll start with the second two, which is the professional trustees and the paid trustees. And I mean, in practice, a trustee is not paid. If you're owner there, you don't get paid. They may reimburse you for expenses, but it's not a standard practice that you get paid. But let's, for this example, assume you are paid. When we look at this regulation 1.22, it also includes scheme executives into the definition of a managing agent. So that means that there is this possibility, and it is there, that you can be seen as a property practitioner when you are a person who manages for remuneration. So thus, paid trustees are property practitioners, professional trustees are property practitioners, and then also a executive managing agent, they still get paid, which means they also are seen as a property practitioner, and they then have to comply with the Property Practitioners Act.
I was just thinking, if you are a professional an executive managing agent, I mean, you step in the shoes of the trustees. Would that have an influence on the fact if you're a property practitioner or not?
So I would say it wouldn't have an influence, because you would still manage on behalf of another. And unless you're doing this as a non-profit and not asking anything, the moment you do get this aspect of remuneration, you fall within the confines of that definition.
Okay, I see that there's another question. How would this apply to self-managed schemes? Say small little self-managed schemes. In this instance, they are saying 6 or 8 units.
Yeah, so as I said, and I think when we're dealing with the aspect of trustees, we need to consider the component of for remuneration. So if we do manage for remuneration as trustees, we fall within the confines of that definition, and then we are property practitioners. But the moment we only manage and we don't get paid for our services, so we simply reimbursed for expenses, it doesn't fall within that specific definition of a property practitioner. So I think that's where the emphasis lies in this situation.
So many, many years ago, when I was still doing management, I took over a scheme, and one of the owners was a chartered accountant. And he, as a chartered accountant, and it was a small scheme, I think it was 12 sections that was in the scheme. He, as a chartered accountant, actually did all the bookkeeping for the scheme. So did all the month-to-month entries in respect of the levies required and the levies paid and payments made and so forth. But that was to the extent that the services or his services was used. They then had a board of trustees that then made the decisions regarding how they're going to or who they're going to appoint as a plumber or an electrician and so forth. What would be the position with that person that's doing the accounting? and he was paid for it because he's an accountant by profession, so he was paid for his services.
So my view on this, and again, there's unfortunately there's no finite answer to this particular question, and the reason for that is the apparent lack of guidance from the Property Practitioners Regulatory Authority. But in that sense, he doesn't conduct a function as a managing agent as a whole, because he's only doing the accounting function. So in my view, I would say then he would be more considered as a service provider. And I know it doesn't fit nicely into that bracket, but it's more as a service provider, and then it would not be seen as a property practitioner. But again, the big frustration, I think, in the industry is that we have all of these questions, but none of them seem to be answered by our governing body.
Yeah, one will also have to see where that line is going to be drawn in the sand. When is it now regarded as a property practitioner and when is it not? I mean, in our discussion before the webinar that you and I had, I mean, the definition goes further and it also includes staff and personnel. So maybe that's also a discussion that we can have. I mean, the definition, you can give us the full definition. I think you've got it in front of you there. Where it also says that it includes your staff, so a property practitioner and its staff.
Yeah, so it has a catch-all phrase where it says any employee who acts or who works for this property practitioner and conducts in the ordinary business is also then seen as a property practitioner. But yeah, as you've mentioned, where do you actually draw the line?
Because in the example that we had the discussion, must your Teagle now also be a property practitioner because she's in your employ? So where does that line get drawn in the sand? Is it a portfolio manager? Is it a assistant portfolio manager? How can one deal with that if you, for example, a portfolio manager does not have access to finance and so forth, but just merely does administrative tasks? Is there a mechanism that you can actually now make sure that you are compliant? For example, exclude them or so forth. Can one do something like that?
Yeah, so the Property Practitioners Act has got an exemption provision. It is not a general rule, so you have to apply for it, but you can apply for exemptions from any part of the Property Practitioners Act, as long as you can motivate it, and then again, as long as the PPRA agrees with you, or if you've got the litigation appetite, you can go and review those decisions and see what the courts have to say if you disagree with the Property Practitioners Regulatory Authority.
So if you don't want your Teagle to be in there, you can ask that she be exempted.
Yes, you do. And I would suggest that you do, because I think the requirements of becoming a property practitioner may be too onerous for a Teagle.
There was another aspect that we haven't touched on in respect of people that needs to be registered. So in terms of section 16 of the Sectional Title Schemes Management Act, a scheme can be placed under administration by a court of law. And previously, that was, as I understood the law, and maybe wrongly so, I don't know, but it didn't seem as if that person had to be registered as an estate agent. If one now look at the definition of a property practitioner, then one would think that you are managing property on somebody's behalf for remuneration, and therefore you will then fall under that definition. Wouldn't you agree?
I completely agree with you, Willie. And that's the thing again. My suggestion or thought would have been that we would have received some or other guidance note where they now actually informed us that this is the ambit of management, this is what is being excluded from this definition. But unfortunately, we do have radio silence at the moment. So now we should assume the worst case scenario, and that is that administrators, executive managing agents, paid trustees, professional trustees, all of these individuals are property practitioners.
Yeah, Clive also makes a valid point. He says that NAMA has circulated a document in which they are of the opinion that even caretakers in a scheme should be included as a property practitioner. That's also a debatable point. I mean, and in accordance with what you said earlier on, one would then rather apply for that person to be exempt, because that person doesn't really manage. That person actually just performs tasks. So I don't know. It's a very, very wide definition.
Yeah, the advice that I always give a client is, when in doubt in these instances, apply for exemption. I think it's far better to get an answer saying, listen, how did you try and link management to caretaker? But rather that than having them consider that to be the status quo. So apply for these exemptions. It's very important to try and avoid the consequences that we may have. I've not touched on that, but just to give you guys an idea, the consequences are, firstly, that you can get a fine of up to 25,000 for your conduct when you're not complying with the act. Secondly, you can get imprisoned for up to 10 years. And I mean, that's quite severe for being a caretaker and just doing your work and now getting these consequences. And then lastly, you can also get the revocation of your Fidelity Fund certificate. And the problem is the Fidelity Fund certificate has become an essential part of the practice. If you don't have a Fidelity Fund certificate, you're not allowed to conduct your practice. So thus, they're basically, firstly, sending you to prison, and secondly, they may be sabotaging the rest of your career as a property practitioner, because they may revoke your Fidelity Fund certificate.
I see there's Anonymous that has asked if somebody does the entry and exit expansions on the rental units, if you would then require. I think that will more fall under rental agents and sales agents. I don't think we've really looked at that for today's webinar, but off the cuff, do you know?
Yeah, so what I can tell you, and this is again the situation. There's no finite answer at the moment. And the problem is, what does manage mean? Because I can construe management as doing this exit inspection to manage this rental relationship. It's almost an intricate part of a landlord-tenant relationship, is that we need to have these inspections. So if you construe it that way, it would seem that yes, you are a property practitioner, but the same applies to the other way around. So it's quite a difficult question to answer. But again, I would always advise to err on the side of caution. So should you think you're a property practitioner, then take the necessary steps. Okay, so I think now we're getting into the nitty-gritties of today's discussion, which is the prohibition on relationship with service providers. This specific topic, I think, has been discussed so many times, and it's been debated, but let's start with what the Act says. So a property practitioner may not enter into an arrangement whereby a consumer is obliged or encouraged to use a particular service provider to render any service or ancillary service in respect of any transaction of which that property practitioner was the effective cause. And before we start debating what does this now mean and how should we change our practice, I think it's important for us to understand why they're doing this. And why they're doing this is it relates to the equal opportunity principle. So there were practices in managing agencies, in rental agencies, and also in estate agencies where that property practitioner would have obliged you. I'm not going to sell your property. I've got the standard OTP, and in my standard OTP, I've already appointed the attorneys. Similarly, in conduct and management rules, there has been provisions where they said, when you are desirous of selling your property in our complex, you must make use of A, B, and C rental agency or estate agencies, depending on the need. And basically what this equal opportunity principle says, the owner of the property has the right to make these decisions. And it's simply placing that decision, that power, that discretion back into the hands of the consumer, who, depending on the circumstance, would either be the landlord or the owner or the scheme executives, the body corporate at large. So that's the gist of this prohibition, is to take that discretion, or where we as property practitioners are now trying to impose what needs to happen, to take that away, to ensure that the community scheme or the consumer has that right.
Yeah, I think in the industry, where we see this as prevalent is where the managing agent is also the debt collecting agency. So they've got another company that is a debt collecting agency, or they are an insurance brokerage, or they hold an insurance brokerage, or they do maintenance. They've got a large maintenance division or security division. And they then, once they get appointed as the managing agent, they enforce these services on the body corporate and say, you must use our debt collection agency, or you must use our insurance brokerage, or so forth. And I think that's where the problem arises. It also takes away from transparency. It takes away from competition. So I don't think that there's fair competition in the market any longer in respect of premiums, for example, at an insurance business and so forth. So it takes away from that, and the equal opportunity principle cannot be complied with then.
Yeah, interestingly enough, I've seen management agreements that actually includes a mandate for you to appoint service providers. And I mean, we are completely steering away from this now. So we really, where there is a management agreement, if you do have this in your management agreement, please steer away, because I don't want anyone to fall foul to this provision. But we'll now deal with a few practical consequences. So now I, as Dilen, a property practitioner, has now obliged or encouraged you to use someone. What is the consequences? So firstly, where this arrangement is entered, the person who renders the service is not entitled to any remuneration, payment, or consideration in respect of the service rendered. So it's not consequences to the property practitioner directly, but you will have consequences, and we'll touch on that now. But you can see that this service provider will then not be entitled to remuneration. And also, where remuneration now was received, so they have paid the service provider, the consumer is entitled to reclaim such remuneration, payment, or consideration together with interest. So I think hopefully none of the managing agents and role players here had a sigh of relief when they saw the consequences are upon the service provider, because we must not forget about enrichment and damages. And I mean, this is now our direct conduct is a consequence of this damage that this particular service provider now has faced, which means they will have a right of recourse against you. So at the end of the day, the buck is going to stop at you. And if the service provider has the litigation appetite, you may be stuck between a rock and a hard place. And then lastly, and I think this is particular aspects that Willie and I discussed that we wanted to have a chat about, to try and decipher what that meaning with these things. So firstly, in the definition, as I've read it, it says of who the property practitioner is the effective cause. So I've had these questions, I see these trends, and I do understand. I mean, as a practitioner of the law, one sometimes wants to find all of these loopholes, if we can call it that. And I've heard the argument where they're saying that the effective cause relates more to sales and rentals. Willie, what's your view on that?
Yeah, I think in the discussion that we had, I mean, one generally find the word effective cause where an estate agent would sue in respect of commission earned, and he would say, I was the effective cause of that sale. So it has particular meaning in that sense, but I think as words, I think, and that's what is being used at as the normal English, is who caused this transaction to take place. And I think in law, we've got the but for test, but for this action that would not have happened or that happened. So I do believe that if you were instrumental in the negotiation of the contract, the signing of the contract, and the service to be rendered, then you will be seen as the effective cause. What those elements of effective cause is, I'm sure the courts will still outline that for us, like they've done in respect of sales transactions. We will see what that is, how they outline it. But definitely when you get involved and you're pushing for a specific service provider, I think you are on thin ice in that respect. So my suggestion would be to draft a scope of work so that you can say, well, we want the building painted. So a scope of work needs to be drafted. Every aspect needs to be included in there. Then it must go out to service providers to provide a quotation or a tender. And that then needs to be looked at by the trustees. They then need to make a rational decision in respect of the appointment of that service provider. So it's not only a decision of who's the cheapest. I mean, if somebody is not registered with the necessary authority, or the employees are just people off the street and they're not insured, they don't have workman's compensation and so forth, then that business obviously will be cheaper than somebody that is compliant. So all those things will have to be taken into consideration by the trustees when making a decision. But I think the end of it is that that decision needs to be made by somebody else and not the property practitioner. So suggesting people, saying here's 5 different service providers, I don't think that that will get you into trouble, but I think by pushing for a specific service provider, I don't know, that's just my off-the-cuff feeling, but I don't know, Dilen, what is your feeling?
Yeah, so I think you phrased it perfectly. It's the but-for test. So whenever we decide whether or not we are the effective cause, it is simply, but for the management relationship that we have with the body corporate, would they have appointed that particular service provider? And if the answer is yes, then we are the effective cause. It's as easy as that. So yeah, I do completely agree. And then also a suggestion to try and resolve this whole situation, to try and steer away from obliging or encouraging the particular use. One would have to start with a scope of work where the trustees now say, this is what needs to be done. This is our internal requirements, as you've mentioned. And then from there on, we can proceed to now try and obtain service providers. But again, it cannot be one where we tell them, okay, this is the only service provider, because then it's going to seem like we're encouraging the use of that particular one. But when there is a portfolio, and we then again leave the discretion at the trustees, as I've mentioned, and this now comes back to the Sectional Titles Act and even the Companies Act for that matter, is that the trustees or the directors must make this decision. So as long as we leave the decision with them, everything seems to be above board. More than that, and this is even more interesting, and another topic I've now mentioned, as a property practitioner, you are not entitled to oblige or encourage. But there are concerns with this. As an executive managing agent, you now fall in the scope of the trustees, or you, as if you were the trustees, and then you appoint individuals. Similarly with administrators, all of the trustees are removed from their office, and you are now in that capacity. So how does this now relate to being able to oblige or encourage? Willie, what would you say?
I think the answer is easier in respect of administrators. In terms of administrators, the court order is your document that gives you authority to deal in a certain manner. So a court has discretion to grant orders in a certain manner, and as long as that order is granted, I think there's no problem. So because you won't be able to do your work, because you step into the shoes of the trustees, but also into the shoes of the owners. So if you don't make decisions, you don't encourage, you don't you don't decide, then you obviously can't do your job. So from that point of view, I think the founding document of your appointment, your court order, will be clear that those decisions can be made. Regarding an executive managing agent, I think that's one of those sticky ones again, but I think the practicality is that they should be able to make those decisions. How else will they be able to do it? Now, I've seen in practice something that is developing where an executive managing agent is appointed, and then there is a managing agent that actually manages the scheme. So maybe there is a separation then of decision making and implementation of decision. And maybe one can then differentiate between the two there. Although when I look at the appointment of an executive managing agent, one of the key elements of the appointment of an executive managing agent is that person must actually manage the scheme. So if you now give the management over to a managing agent, are you then compliant with your duties in terms of the rules to manage the scheme? So there's many questions in the Act that are not answered as yet, and it seems almost as if the Act was written without taking sectional title into consideration. And again, we are sucking the hind tit here as sectional title people, that the legislator merely thinks of sales and the rentals and not really about property practitioners in this huge industry in South Africa.
This is
difficult.
This is again, it just goes to show the discrepancies in this Act, and should one go through this Act with a fine comb, you will see that there's a lot of these discrepancies, and again, this, and I may sound like a LP that's on repeat, or the same part just continuously playing, but it is as a result of the lack of guidance, and we do need this guidance. Similarly, and something that I just want to touch on, we do understand in this industry, managing agents are normally appointed by virtue of the fact that firstly, they do their job. Secondly, they've got a great network of service providers. They've got great attorneys and stuff like that. So we are cognizant of the fact that you do have this relationship. And I think a lot of times you do get appointed as a result of the holistic solution that you're trying to give them as a managing agency. And trustees, in some instances, also simply don't care. They phone you saying, listen, there's a burst geyser in unit 4, sort it out, or something like that, any emergency situation. And then it's difficult to comply with this rule. But again, insofar as the Act is concerned and the consequences, it's really important as an industry that we do comply with this, the provisions of the Act. And the solution would be, again, leave the decision at the hands of the trustees. In the other industries, leave the decision at the hands of the landlord or at the hands of the property owner. That's the purpose of this provision. And then,
I think Clive
yes,
makes a valid point. He says in respect of larger projects, like I mentioned, the painting of a scheme and so forth, it's easy to then do a scope of work and get a tender process in place and so forth. But the day-to-day decisions, that those small little decisions, like the one you said, a burst geyser, those are the ones where the trustees don't really want to get involved in that. They want to say, well, get the plumber here that did the job last time and let him come and do it and get it over and done with, because we want to inconvenience the member of the scheme as little as possible. And that is where the problem lies. What we've done is we've drafted and Dilen has done that for us, that we will give away as a free resource. We've drafted a trustees resolution, and that trustees resolution will then place the decision on the trustees, but you can then, as a managing agent, utilize that constantly as the authority to have appointed the person, and in that way you are in some or other way indemnified at least, or we try and indemnify you at least in that respect. And Dilen, we must just have a look at that resolution and see if we can't just give a standard authority that can be withdrawn at some stage in respect of certain service providers. Because the Act does make provision that one can delegate certain functions on the basis that you can withdraw them at some stage. So maybe by doing that, we then protect the managing agent in that regard.
I think
because we don't know what's going to happen, and we need to try and protect the role players in the industry.
Yeah, I think prescribing reasonable conditions, and I may sound like a member now, in a member-trustee relationship, but again, giving the trustees the authority to prescribe reasonable conditions, perhaps a specific budget. So if you want to do something for R1 million, listen, you're going to have to come back to us and we'll have to resolve again. But just to ensure that there's that safety mechanism. But yeah, I think pre-approval to an extent, if we can call it that, is the way to go with these types of urgent aspects where we just need to get someone out now. And us having to take the time to convene a meeting or to get all of the trustees to sign simply won't work for what is going on. I think the thing would lie that we need to try and pre-approve these types of resolutions and service providers.
One last aspect that I want to hear your point of view on is what happens if I see that Anonymous is asking that, and I know that many managing agents does that, and even on my statement that I'm receiving from one of the largest managing agents in the country that I get on a monthly basis, it says plumbers, and it gives you a number of a plumber, electrician, after hours electrician, or emergency plumber, or whatever. So it does have certain service providers numbers on there, but those service providers are merely there. The managing agent does not get remunerated or does not get anything out of this. It's just merely because they've built up a relationship with this person and they know that they will do the emergency service required.
Yeah, so from my side, the big thing is the fact that they use the word encourage scares me, to be honest, because this makes this provision almost all encompassing. But my advice would always be in that regard, just don't include one number. Try and still ensure that they have some or other discretion, if we can call it that, so that we avoid falling foul to this encouragement. And again, I do believe this section is going to be one of the first sections that will be tested in our courts, because I think the first time that a service provider with a major job is being called upon to pay all of the funds back, there is going to be a full-on legal issue there, and then there will be litigation appetite. So let's see when the courts interpret this provision. Hopefully we'll get that guidance so that we can actually try and more affirmatively address these types of issues.
And then there was just one last question. It's not really relevant to what we're talking about here, but it's a question about the right to choose the color of paint. In my experience, if this was not placed as a prohibition in terms of Section 7 on the trustees that they cannot act in a certain way, I would think that it would be their decision to determine what color must be painted, or am I wrong in that respect?
No, I completely agree with you. Again, this relates to day-to-day administration. As this trustee or as this director, you are tasked with making some crunch time decisions, and should that be the color of the paint outside of the scheme or wherever you want to paint something, and there's no condition or restriction imposed upon you, you have carte blanche in that instance.
I agree. We might be wrong, but I think that's what it is. I mean, if there was no restriction, then, and it wasn't noted as such in your minutes, then the trustees, as the people that are managing the day-to-day affairs, can make that decision. Dilen, thank you so much. Sorry to everybody that we started a bit late. We had some crisis issues here on our side in respect of the internet, but luckily we sorted that out, and we will send out that resolution to you all, and we hope that you've learned something from today's webinar, and we again thank Dilen from the Twee Burger for assisting us with this.
Yeah, thank you, Willie. I've secretly been admiring the show, and I've watched it. I even call it a show. It's not just a webinar, it's a show. And I religiously have a look at this. Even R1, I'm going to have a look at it, and I'm going to be proud of what you guys are doing. So I'm just appreciative of the fact that I can be part of this and be part of ensuring that the industry is informed. I mean, at the end of the day, and I always say this to all of my clients, is the steps that we take to educate the industry at large makes my life easier.
Definitely.
So I really appreciate it. Thank you everyone for joining as well. You are the star players in the show because you are the people taking the time to listen to me and Willie's boring voice. So thank you very much for attending. I really appreciate it.
Thanks so much.
Thank you, everyone.